Those of us who thought that the World Court was a legal corpse, or perhaps more kindly, a legal snail, would be surprised to know that one of the very few occasions in which the court's jurisprudence has had an immediate and galvanising impact on world affairs was when it declared that Morocco had no sovereignty, no claim as sovereign on the territory of Western Sahara. Because within a matter of days, the Sultanate, or the Kingdom of Morocco, I think it is now, organised what it called a green march of hundreds of thousands of Moroccans across the border into Western Sahara in a physical attempt to lay claim to its much disputed and scorned claims, scorned by the World Court, claims of sovereignty over the territory of Western Sahara. Now, green is not the colour du jour in North Africa, and perhaps because some of the rumblings from the Arab Spring have been felt in the Sultanate's premises in Morocco, and some steps have been taken, faltering steps perhaps, but steps nonetheless, to introduce democracy and a human rights council to Morocco, assertions for which would have led to your imprisonment if they had been published in Morocco 12 months ago. Perhaps we may see also some change afoot in the Moroccan attitude to Western Sahara. Because when the World Court scotched the Moroccan claim to territorial sovereignty, and it did so in language which was unmistakably clear, unlike much of the discourse in international law, when it did that, it became obvious that if Morocco did seek to fill the political void in Western Sahara, it would do so not as the administrator of a non-self-governing territory in that lumbering language used by the UN General Charter, but it would do so as an occupying power. Of course, there is a vast difference in legal consequence between an administrator of a territory, we think in Australian terms, of the years where we administered various forms of Papua New Guinea as mandate, trusteeship, and then bringing it to independence in accordance with the UN Charter and the resolutions of the General Assembly for decolonisation, slowly but surely, inevitably. We think of that, but when we look at the situation in the Western Sahara and contemplate this for a moment, that if you look at the history of the last 40 years, 50 years, it's a history on the African continent of decolonisation, of trying to work out the problems that the claims of sovereignty by European powers had brought Africa, whilst preserving the boundaries and the greater interests of peace and security. Non-disturbance of boundaries that had been set up in colonial times was a fairly fundamental principle, and is again to be found in the Charter and in state practice, because that is seen to be, through the experience of the ages, the incitement to violence that most frequently arises. the non-disturbance of boundaries was one thing, but in 1960, the General Assembly, the law-making body of the United Nations, the General Assembly declared that there was a right of peoples to self-determination and a right of those peoples to control their natural resources. For their natural resources, if they happen to be occupying or present within a non-self-governing territory pre an act of decolonisation, resources that could only be used with their consent or participation and for their benefit by the administering power. And that's a return to the weasel word, administering, not occupying power. The system that had been set up, originally based upon the mandatories under the League of Nations, and then translated principally through the drafting of Dr. H.V. Evatt into a system of trusteeship in the UN Charter, recognised that there was a right to govern located in a sovereign state that acted as if it was a trustee for the people or peoples who lived in the non-self-governing territory, the territory that was in the process of decolonisation. Now, the second fundamental principle that was embraced in those days and remains the case today was that self-determination involved a free and voluntary act on the part of the peoples, essentially a democratic act to select for themselves who was to be their sovereign, whether it was to be their neighbour that exercised the powers of trusteeship, whether it was to be a sovereign appointed or elected by themselves, or whether it was to be a kind of halfway house where they would exercise autonomy within a broader nation, where they wouldn't themselves be sovereign except in that kind of delegated sense of a semi-autonomous nation. Now, those were essentially the three choices that an act of self-determination involves. And really this is the tale of three cities when you think about it, because something was in the air or in the water in 1974 and 1975, and not just the dismissal of the Whitlam government. What was happening in 1974 and 1975 was happening at the same time across the globe, but roughly parallel. Three cities, three places if you like: Papua New Guinea, the final act of decolonisation and independence in 1975. East Timor, the Portuguese walked out on East Timor, leaving a political void which was then filled by Indonesia. And then the Western Sahara, because at about the same time, within months of the Portuguese walking out of East Timor, the Spaniards prepared to walk out of Western Sahara, and indeed did so the following year in 1975. So there are three parallel acts occurring, two of which directly concerned Australia and Australia's interests. And how did we react? We were formal trustee in the case of PNG. Non-self-governing territory, an act of self-determination, a new state evolved with Australia's consent, encouragement and funding. No one can criticise what occurred there. East Timor, a complete mess, resolved only by, again, an act of independence, of self-determination by the Timorese people, ultimately presided over by the United Nations. But at the same time, but before then, Australia had entered treaties or agreement contracts with Indonesia for the exploitation of resources, oil and gas resources in the Timor Sea. Contracts which in international law would be unlawful unless they were undertaken for the benefit of the Timorese and with their consent, and plainly enough Indonesia did not receive either. Nonetheless, to approaching independence, Australia ensured that those contracts would be enforced and implemented with the approval of the UN governing power in East Timor, which in turn consulted the East Timorese people. Again, a bit rough and ready, but in the outcome, a fairly impeccable example of implementing the principles of self-determination. The third example, in 74-75, was Western Sahara. And what happened there, it seems to me, was shameful. It was shameful because there had been resolution after resolution in the United Nations General Assembly and in the Security Council. There is no nation in the world that recognises the sovereignty of Morocco over Western Sahara. None at all. That's extraordinary. The African Union, for what it's worth, and it's perhaps worth something in international practice, sits a representative of the government in exile of Western Sahara. A third of the nations of the world recognise the government in exile of Western Sahara. Yet the international community permitted, through inaction, the Moroccan army to build a wall, the like of which I don't think we've seen since Hadrian, a sand berm, splitting the nation, more or less, or splitting Western Sahara, so that the valuable resources of the sea and coast and of the hinterland, in particular the phosphate resources, could be plundered by the Moroccans without the consent or approval or any act of consultation whatsoever with the peoples of Western Sahara. And that is a fundamental breach of a legal principle, the principle of self-determination, which international law recognises is fundamental in the sense that you can't make a valid treaty in breach of it. You can't make a valid contract in international law in breach of it. So that is how I see the circumstances in which Western Sahara is currently placed. The question that interests me is what happens, and I don't know whether you were told, but I'm a non-executive director of a multinational grain company. So I've got some understanding of the need for phosphate as a plant nutrient in order to grow plants in arid soils. Australia has arid soils and it requires phosphate in which to grow many of its staple crops. Australia is one of the largest purchasers of phosphate ore from Western Sahara. A number of major companies, I'll name two, Wesfarmers and Incitec, purchase that ore and process it in Australia and then on-sell it or use it in their own agricultural pursuits. What is their position? What is the position of those private companies? Now, we all know that private corporations and individuals are not actors, the term, I suppose, in international law, which means that they've got no legal standing that enables them to take proceedings in international tribunals on their own behalf. Their cause has to be championed by some nation state that has a recognised interest in the substance of the dispute. In local law, we call it standing rules. Individuals and corporations don't have standing, speaking generally, but in some particular instances, the activities of a corporation, and indeed individuals, do resonate in international law. Let me give you two examples. If you enter a contract with an overseas party, the contract requires you to implement something, say to purchase resources that are extracted and sold in breach of international law, then that contract may be void under the law of Australia, because it's a contract entered into for an unlawful purpose. Another aspect to this is the ability to enforce contracts in international forums. Let me give you an example. No foreign investor in a third world country will invest without engaging the protection of a bilateral investment treaty or local legislation which locates disputes concerning the investment in an international arbitral tribunal. Those tribunals are known by, we're in the world of acronyms here, known by the acronym, which is slightly easier to pronounce than most, ICSID. ICSID. And we have a number of distinguished judges, or former judges, including especially Andrew Rogers, who used to be the chief commercial judge in New South Wales for many years, who sit on these tribunals. And they recently decided in a case concerning duty-free shops in some benighted African country, that when the owner of the shops took the bag, the briefcase in to see the president and left it there with the $1 million or so for which he procured his duty-free concession at all the airports in the country, and then subsequently sued the country when it reneged on the contract for the duty-free stores, he couldn't enforce that contract in ICSID, in the International Arbitral Tribunal, because it had been procured corruptly. Contracts that are procured in breach of international law, particularly fundamental norms of international law, in my view stand in exactly the same position. Those who trade with countries such as, or rather entities of the Moroccan state in West Sahara, are at risk of a finding, if there's a breach of the contract and they seek to enforce it at an international tribunal, they're at risk of a finding that the contract is unenforceable. Now there's another principle which we're all vaguely aware of, I think, and that's the international crime of pillaging, where the occupying power or its officers pillage or plunder a community. We think perhaps of the Greeks sailing off to Troy in search of a woman and plunder, gold and brass and statues and women or whatever, and bringing them back to Greece. That kind of plunder was outlawed by the Geneva Conventions, and the laws of war extend beyond actual hostility and into the period after war, where by dint of the war a power occupies territory without sovereignty, hence Morocco, and engages in economic plunder. Indeed, in the Nuremberg Trials, there was some fellow, some glorified clerk in the Nazi bureaucracy who was responsible for taking the coal from Poland for the Nazi war machine. Because Poland was occupied, he was charged with the international crime of pillage, because he'd extracted, without the consent of the Polish people, a non-self-governing territory of a warlike Germany occupied by the Nazis, extracted the coal and didn't compensate the state, didn't compensate Poland. And he was found guilty and sentenced and ultimately released only, I think, during an amnesty in 1951. So there is precedent within the international criminal field of prosecution of persons who a part of the apparatus of an occupying power that engage in the international crime of pillaging or plundering a nation's economic resources. So there are a number of different areas where international law can intersect, and intersect in Australia, or affecting Australian interests with West Sahara. But the one that, because I'm basically come up from a black letter, despite my appearance, because of my appearance perhaps, from a black letter law background, that's where I mostly practice. It occurs to me, and this is the only Latin phrase I will use, and you should be very grateful to me for that, because getting lectured by international lawyers usually involves a sea of Latin. I think of the rule that we lawyers call Nemo dat, that's just short, I won't quite know that, which says that you can't gain title from buying something that the seller didn't have. So if the seller doesn't own the goods that you're buying, you don't get any better title than the seller. So when Australian companies purchase goods that are the product of extracting resources in the Western Sahara without the consent of the peoples of the Western Sahara, without consultation with them, and it's even assuming that Morocco is an administering, not an occupying power, an administering power, still has to get the consent and act in the best interests of the people of the Western Sahara before it can lawfully exercise sovereign powers over the natural resources of that territory. That's well understood in Africa. Just think of Namibia and South Africa and the extraction of uranium, which caused endless problems in Africa for many years. It's a well understood concept in centres of decolonisation. How does Morocco, Morocco's entity, when selling the ore or perhaps allowing the sale of fish, in the case of the European Union, how does it pass good title? The World Court has said it doesn't have sovereignty in Western Sahara. The company that's selling is an organ of state of Morocco. Where does it get its right to pass good title? Now, I've been thinking about this, and there have been cases over the years. I mean, I remember the case about timber, about a Russian, after the Soviet Union was established, whether goods belonging to a Russian timber company title in them could be passed. Things of that nature. I mean, there have been a number of cases in the books, but it seems to me that's mostly pre-Second World War. What we have now is a new principle which says historic title doesn't matter any longer. What matters is the right to self-determination of peoples in non-self-governing territories. That's a completely different legal construct to the time before the Second World War, where people tended to find sovereignty in those nations that had historic title. Now, they argued historic title in the World Court, in the Western Sahara case, and the court said Morocco couldn't prove historic title, and the treaties and conventions that Morocco relied upon, and the dealings that it had with Spain and other nations, all established a contrary principle, were all explicable by Morocco having no more than religious ties to the tribes that occupied Western Sahara, and perhaps some political ties, but never sovereignty. Never sovereignty. Even on a historical title, Morocco failed. And as I said, no one has recognised its sovereignty. So how can the office that sells the phosphate pass good title to Australian companies? Now, there's another dimension. There's another dimension. this ore is being imported into Australia and can only be imported if you fill out a form. That's putting it at its most basic. I can spend considerably longer than 10 minutes taking you through the interstices of the Customs Act and regulations next time. But what it amounts to is this. There's a very simple thing you have to do when you import something to Australia. You have to fill out a form and answer this question: country of origin. And if you fill that form out and make a misstatement, let's leave aside the questions of knowledge or not knowledge, or notice or no notice. If you fill out the form and make a misstatement, you've committed a criminal offence under the Customs Act. Now the companies that have been importing ore from Western Sahara have all, with one, I think, exception, after some investigations were undertaken and that I requested, have all stated that the country of origin is Morocco. One, somewhat sensibly, said Western Africa, and I suppose Customs let him get away with it. But in the Customs computer, there is an acronym for Morocco and another one for Western Sahara. So there was a choice. The choice was consciously made by those Australian companies to state that the country of origin of these goods was Morocco, and that statement, I'm here to tell you, is false. Because there is nothing more certain than that. In municipal law, the failure of Australia to recognise Morocco as the country with sovereignty in Western Sahara, and the failure of the rest of the international community to do so, means only one thing, and that is, it is false to state that this ore is imported from Morocco. That is not its country of origin. These are serious criminal offences. There are reasons why there should be an accurate statement as to the country of origin of what are essentially organic materials. There are phytosanitary reasons why that should be so, apart from anything else. I'm not suggesting that in this particular case there are phytosanitary reasons for rejecting shipments of ore from Western Sahara, but that's the reason, that's one of the many reasons for the customs requirement. And it is being regularly breached by major listed Australian companies that should know better.